word crowdfund, what does it mean? It means we're going out publicly and asking people to finance our deal. And that can take different shapes and forms. In the legal sense, crowdfunding means something very specific, but you can crowdfund a Regulation A deal like Grant Cardone's, or you can crowdfund a Rule 506C offering, which I will get into, which is for accredited investors only. And most of the major, I wouldn't say most, but a lot of the major crowdfunding, real estate crowdfunding platforms operate specifically under 506C, which is for accredited investors. I'm going to get into what that means. Or you can crowdfund under Regulation CF, which is the legal term. If you said crowdfunding to an SEC regulator, they would think you meant Regulation CF, and I'll talk about what that means as well. The other way you can go out and raise capital, which is what most of you are going to do, is use private money without using general solicitation. And finally, I mentioned a mini IPO. I'm referring to Reg A again there. And so to determine which way you're going to go, you got to look at three things as far as I'm concerned. You got to figure out where your business is. If your business is just starting off with raising private capital, then using a mini IPO doesn't really make a whole heck of a lot of sense. You're going to spend a lot of money on legal fees and putting it all together. You have to know who your investors are. And then finally, you want to know how much money you need. And that will kind of determine which strategy you use. Then to get the investors through the door, how are you going to do that? Are you going to use a crowdfunding portal? Are you going to do content-based marketing, which, by the way, is my favorite way to raise capital? Or are you going to network for investors? And we'll talk about that as well. And for these things, you have to kind of figure out, what are you comfortable with? Are you comfortable with going out and talking to people? Are you comfortable with networking with people on the internet? Are you comfortable with writing articles and doing videos and educating people? And all of this stuff does require some kind of budget. Getting investors through the door is a lot of work. It's not easy. If anybody says that it is easy, they're not telling you the truth. You can make it easier, but you have to have a consistent message, and you have to consistently go out and be, whatever it is you decide to do, you have to do consistently. And that's like with anything, like exercising. If you exercise once or twice a month, that is not going to give you any results. You have to consistently exercise. You have to consistently eat well. It's the same with raising private capital. You have to consistently get a message out there for investors, for them to understand why it is that they should invest with you. Okay, so real quick, I just want to go over what the law timeline looks like. So if we go all the way back to the Great Depression, this is where it all began. The Great Depression, we saw the stock market crash, and coming up to fix all of that, in 1933, Franklin Delano Roosevelt came out with the New Deal. And the New Deal, part of the New Deal was the Securities Act of 1933, which is still good law today. It's the federal law, and it is the law of the land when it comes to securities laws. It trumps all other laws. Now, states can supplement those laws, and the Securities Act of 1933 in certain circumstances gives states leeway to make their own rules and regulations regarding securities. But the overall law of the land is the Federal Securities Act of 1933, which is why, even though I'm only licensed to practice law in the state of California, I can represent clients all over the country. And I do represent clients all over the country because it's federal law. So we're able to do that. So fast forward to 1946, and this is really important, and I will get into this in a little bit. We had a case called the W.J. Howie case, which defined what a security is, and it's going to be really important to you. Then the crowdfunding laws came out. That's the Jobs Act. The crowdfunding laws came through this thing called the Jobs Act, the Jumpstart Our Business Startups Act in 2012. And then what had to happen after that is the SEC had to write rules on how they were going to carry out the Jobs Act, and that became completely legal in 2016. So that's just a little history so you understand how we got here in the first place. So I had mentioned early on that different types of investors are treated differently under the law. So there's 3 types of investors under the law. So let's take a look at those. There's the lowest common denominator investor is the unaccredited investor. And you may be offended by what I have up here, but it's something to help you remember the rules a little easier. So unaccredited investors you can refer to as not so smart and not so rich. Then the second tier of investors are called sophisticated investors. And these, and I promise you, probably everybody who is attending this is probably to some level a sophisticated investor. And those are people who are smart, but not so rich. And then our highest investor is an accredited investor. And that's somebody who makes $200,000 a year as an individual, $300,000 a year as a married couple, or has $1 million net worth exclusive of their primary residence. Now, let me just tell you, you know, I get a question all the time, like, how do I become an accredited investor? And you don't become an accredited investor. You either are or you aren't. You can't get accredited. So you either make $200,000 a year or you don't. You either make $300,000 a year or you don't. You either have $1 million of net worth or you don't. There's no society to accredit you as an accredited investor. Now, how do you become a sophisticated investor? Well, you get educated. And the sophistication test is a subjective test. You, along with whoever you're investing with, have to determine, are you sophisticated enough to sufficiently understand the risks associated with investing? And if you're asking questions like, is it guaranteed? Is it low risk? Then you're probably not sufficiently sophisticated enough. Or if your investors are asking you, is it low risk? Is it guaranteed? They're definitely not sufficiently sophisticated enough to invest with you. So keep that in mind when you're looking at investors and applying that sophistication test. So let's take a look at the rules. Okay, so now I've mentioned a couple of things here, and I apologize because I thought I had another slide in between here that's missing, and it was the slide that I thought I had in here was a picture of a farm. And why did I have a picture of a farm? Well, I'm going to actually go backwards real quick because I want to go back to this timeline right here. And I had mentioned this, this W.J. Howie case in 1946, right? This is really important. It's a really, really important case. It's still an important case today. So why is this case so important? Well, because it defined what a security is. And I feel like there's a lot of confusion regarding what a security is. And this, if you're taking notes during this event or during this particular session, this is the thing I want you to write down. The test is what a security is. And the test is, if there's an investment of money, there's more than one investor, the investor expects a return on investment, and the work is done through the efforts of a promoter. So the efforts of a promoter, what does that mean? Well, that means that you're doing all the work. So if you're going out and you're looking for investors for your deal, and your investors are coming to you and saying, yes, I'm going to invest with you, and not only am I going to invest with you, but I expect you to give me my money back, and then I expect you to give me some other money, whether it's interest, profits, preferred return, whatever it is, and then you're going out and making that all happen for them, that is a security. And why is that important? Because that means all the securities laws apply. And so, you know, I see people constantly try to get out of securities laws, like say, well, I don't want them to apply. But I'm telling you right now, if you're taking investors' money and they're expecting a return on their money and they're expecting their money back and they're expecting you to do all the work, you're selling a security. So that's why this is important. So to resume this presentation, then we're going to take a look at, okay, so now that I know I'm selling a security, what are the rules? How does it apply? And as the way I look at it, I call these buckets. Now, there's more than the 4 buckets you're seeing here on the screen right now, but these are the major buckets that you can choose from. And really what you're going to be really looking at when you're making your choices of how you're going to go out and raise money are 506B and 506C. These 2 in the middle are really the ones you're going to be focused on. So I'm going to start with those bookends, crowdfunding and Regulation A, or mini IPO on the right there, and then we'll come back to the middle. So under crowdfunding, and this says $1 million, it's actually $1,070,000. So you can raise up to $1,070,000 using crowdfunding on a registered crowdfunding platform. So what's a registered crowdfunding platform? That is a crowdfunding platform or crowdfunding portal. They actually refer to them as portals. A crowdfunding portal that has been registered with an organization known as FINRA. And they act as a mini broker dealer, like and they're going to broker your particular deal. And they're going to take a percentage of that deal, and they might even charge you a flat fee to get listed on their website. So you have to find one of these portals that are registered with FINRA, and then you can raise up to $1,070,000 on that portal or through that portal, and take money from any type of investor. So if you remember our 3 types of investors: accredited investors, unaccredited investors, and sophisticated investors. All of those investors can invest in your deal if you are doing a crowdfunding deal under Regulation CF. That's the regulation, Regulation CF. If you're doing a crowdfunding deal under Regulation CF on a registered crowdfunding portal, you can take up to $1,070,000 from any investor. Oh, and real quick statistic about those 3 types of investors. You know, I had said, you know, not so smart, not so rich is kind of derogatory, and it is. It's not really fair to call, you know, a section of the population not so smart and not so rich. But I do want to clarify that depending on what statistic you're looking at, only 3 to 10% of the entire United States is considered accredited. And obviously, if you're looking at the net worth requirements, that can ebb and flow with the economy as well. So the reason why we have to be really concerned about that is because there is a whole swath of the population, and that, you know, up to 97% of the population that may be considered not accredited. So then up to that, you know, 90 to 97% of the population, a certain percentage of those people are considered sophisticated investors. Now, for Regulation CF, it's slightly irrelevant. And why is it slightly irrelevant? Because anybody can invest under a Reg CF offering. So $1,070,000 on a registered crowdfunding portal, that's what you can raise under Regulation CF. Now, I am not a huge fan of Regulation CF, which is really ironic because the name of our law firm is crowdfundinglawyers.net. But like I said, you can crowdfund under several of these buckets. But under regulation crowdfunding, I'm not a huge fan. Why? Well, if you look below there, the limit for an investor under Regulation CF offering is $10,000 or 10% of somebody's net worth, whichever is less. So you're taking a lot of small money from a lot of investors to get that $1,070,000, right? So it's not exactly, you know, the Shangri-La we were hoping for. But to back up even further, when you get listed on one of these registered crowdfunding portals, first of all, a registered crowdfunding portal has to accept you, which can be difficult in and of itself. These portals are getting pickier and pickier on who they allow on their portals. And I actually kind of like that, because I think, you know, there's a lot of people who want to go out and raise $1 million and don't really know what they're doing. So I do like the fact that these portals are getting a little picky in terms of who they allow to list on their website. But so that's number one. You got to find a portal that's going to take you They tend to be very picky. Number two is when you go on there and start raising money, there's no guarantee that people are going to invest in your deal, and the portals will tell you that straight up front, and they only push the deals that they believe are really going to raise a lot of money because they're bringing their own crowd. So there's that. Then the third thing is, the investors who invest are probably going to invest small amounts of capital. As a matter of fact, the average investor invests only $250 on each crowdfunding deal. So keep that in mind. Your average investor is going to invest $250. And finally, it's going to cost you money. And they're, dollar for dollar, crowdfunding campaigns tend to be more legally expensive, or just not even legally expensive, but just marketing expense, everything dollar for dollar more expensive than the other types of offerings, believe it or not. Because you can pay up to 7 to 10% of the capital you raise in marketing and legal and audits, all that other stuff. You do need to get an audit for a regulation crowdfunding type of offering. So these are all kinds of things to consider. So then let's go over to our other bookend, mini IPO. This is Regulation A. This is what Grant Cardone did. And Regulation A plus under Tier 2, which is the only real Regulation A I recommend. Under Regulation A plus Tier 2, you can raise up to $50 million from any type of investor. So accredited, unaccredited, or sophisticated investors can invest in your Regulation A Tier 2. And you can advertise for those investors on the internet or wherever you'd like to advertise for investors. But the thing is, the big but with the Regulation A is that you do have to get approved by the SEC. It's way legally more expensive than our two middle ones there. So really something to consider is that it is a lot more expensive to do a Regulation A. That's why you don't see a lot of smaller companies doing them, because it can get really costly, legally speaking, and you also have to do an audit. And so that's something to consider. So let's talk about our two middle ones, the ones that you're going to be considering as a real estate entrepreneur trying to raise capital. 506B is the old rule, still a good rule, allows you to raise as much capital as you want from a combination of both sophisticated, that's our level 2 investor, and accredited investors, an unlimited number of accredited investors. You can take up to 35 sophisticated investors, but not just purely unaccredited investors. So these are people who understand the risks associated with investing. You can take money from people who might not be accredited, but do indeed understand the risks associated with investing. So, but you cannot use any general solicitation. So in other words, you can't advertise for investors. You can't go on Facebook saying, I'm looking for investors. You can't get up in front of a middle of a RIA room and say, hey, I have this deal and I'm looking for investors. Come talk to me later. None of that can be done under Rule 506B. So let's say you do want to advertise, then you could use that second middle one, 506C. Rule 506C right here. So you could use Rule 506C, and Rule 506C allows you to raise as much money as you want. You can do general solicitation, so you can go on Facebook, you can go to the front of the room, you can advertise for investors saying, hey, I'm looking for investors, but you can only take accredited investors, and you have to verify that those investors are indeed accredited. So that's the big difference. So where can you advertise for investors? Well, let's take a look. You can advertise for investors under Rule 506C, Regulation A, and under Regulation CF. And I'm going to give you guys a little something you can do. If this is hard to remember, I'll get you a chart that you can send to that you can get. As a matter of fact, I want to figure out, I think that you can actually get, hold on one second. I have a way you guys can all get a chart and some other awesome stuff that will help you with remembering these rules, because these rules are not easy to remember. And I get pretty much the same questions every week on these rules because they aren't easy to remember. And there's a lot of numbers, and there's a lot of letters, and there's a lot of different types of investors, and there's a lot of different rules. So I'll get you all that information. So, so you don't have to furiously take notes and try to remember all of this. All right, so where can we advertise? Under 506C, Regulation A, and Reg CF. Okay, so moving on. I did some analysis, and I've been looking at the Reg D filings since 2014, which is when the Rule 506C, where you can go out and raise capital using general solicitation only from accredited investors, came out. And so here's what the Regulation D filings showed me. Now, I wanna just draw something real quick, because I just threw out there like this new word or new phrase, Regulation D. So I have this new phrase, Regulation D, right? So I'm sure a lot of you have heard of that before. Now, previously I had mentioned, wow, this is not easy to write with. Okay, so previously I'd mentioned 1933, the Securities Act of 1933. So that's the umbrella under which Regulation D is under. So Regulation D is what's called an exemption from registration of securities. So then under Regulation D, there are rules. And under Regulation D, and this is what I'm referring to here, is our Rule 506. Okay, so, and then under that is B, you remember, no advertising up to 35 sophisticated investors, and C, advertising, but only accredited investors are allowed. Okay, so anyhow, I pulled all the statistics, and here are what the statistics said. Since 2014, there's been 77,000 filings under Regulation D. And here's how all of it broke out for real estate. So pooled investment fund and real estate are pretty much the same categories. Pooled investment fund might be mortgage notes, it might be a real estate fund, what have you. And that real estate 6% can mean like a single syndication of a multifamily building. So it just depends. But this is how it all broke out. So we can see a big, huge chunk here is specifically for real estate or real estate related assets. So one such famous offering done under Rule 506 since that time was an Airbnb offering for accredited investors only. So kind of cool if you got in on that, right? So, but here is a really shocking statistic. So any of you out there that are thinking right now, well, I really want to do Rule 506C because then I can advertise. I hope I'm about to blow your mind with the statistic. And here it is. Since 2014, it turns out that only 7% of all those offerings we just saw have been done under Rule 506C. The other 93% have all been under B. So what does this mean? This means that people aren't finding, or issuers are not finding, the value in advertising that they thought they would, and instead are sticking with people who they know and who they network with and who they educate, as opposed to forms of general solicitation. So just keep that in mind when you're all gung-ho about doing a Rule 506C offering, okay? So, but just to give you an example, this is a screenshot of a website that many of you may be already familiar with, called CrowdStreet. And CrowdStreet is a crowdfunding platform that operates under Rule 506C. So all of these offers here are actually under Rule 506C, okay? So what I really want to impress upon you before I take questions here is that people you know are always going to be greater, better, badder than people you don't know. Your Uncle Joe is more likely to invest with you than a woman you've never met before on the internet. So keep that in mind before you consider the differences between 506B and 506C and go running head first into a 506C offering, because people you know are always going to be better than people you don't know. You've built that trust. They trust you. They know you. They're more likely to invest with you than people you do not know. So Just to recap, what are the pros and cons versus 506B and C? 506C, strangers. B, people you know. How do we get investors through the door with 506B if we can't use general solicitation? Well, education-based marketing, branding-based marketing, no verification or accreditation of accreditation is required, and you can have up to 35 sophisticated investors in your deal that are not necessarily accredited. And you need all of that. You need to verify that you have only accredited investors in your deal if you go out and use 506C, but you can use general solicitation if you do. So when would you consider 506C? Now, you know, poor Payless, they're gone now, but I thought this was so ingenious of them, right? You know, their swan song. This was kind of their swan song. They opened a pop-up store called Payless, and they had, you know, people all dressed in black, and then they invited out some YouTube influencers, and all they did was just display the same shoes that you'd find a Payless shoe source, and displayed them in fancy shelves with fancy lighting in a fancy environment, like you see there on the right. And I brought in these YouTubers, and then would ask these YouTubers, what do you think of these shoes? And the YouTubers would say, oh my God, these shoes are amazing. I love them so much. Well, how much would you pay for these shoes? Oh, I'd pay at least $400 for these shoes. And it turned out it was the same shoes that were available at Payless for, like, you know, 25 bucks. So, you know, perception is everything. People are willing to pay more based on perception. So why would you consider a Rule 506C where you can only take accredited investors? Well, you would use 506C if you already have a long list of accredited investors. Look, even though you can do general solicitation, it still comes down to people you know and who are familiar with you are going to invest with you before people who don't. It's just easier to reach them and be more direct with them if you're doing a 506C offering, right? Because you can say directly to them, I'm looking for investors in a general solicitation without having to be sly about it. Maybe you have a budget for general solicitation. You do need a budget if you're going to go out and do general solicitation. You know, as we know, Facebook ads cost money, so do Google AdWords, so do websites. All of this stuff costs money. You have a website that can process subscriptions. There are a lot of white label software providers out there that can provide you the services in order to process subscription agreements from your investors online. Now, I just used a word there that some of you might not know, or a phrase there that some of you might not know, and it's called a subscription agreement. So why is this important? A subscription agreement is the agreement between you and the investor that says the investor has read all your legal documents and now understands what's going on and is willing to invest with you on the terms and conditions of those legal documents. What are the legal documents? One such legal document is called a private placement memorandum. So when you're dealing with investors and you want to say, hey, investor, do you want to invest with me? And the investor says, yes, I'm interested. You have to present them with something that's called a private placement memorandum. And a private placement memorandum is a legal document that tells the story of the investment for the investor, so they understand the risks associated with investing. So it's not just a matter of going out and looking for investors and getting them in and following the rules regarding general solicitation and types of investors. It's also providing the proper disclosure to an investor. I don't have a slide for this, but this is something I call the 3 Ds: disclose, disclaim, and details. So you need to disclose all the material facts. You need to provide all the details to the investor so that they can make an informed investment decision. And you need to disclaim any liabilities. And you do this through the private placement memorandum. The private placement memorandum is also going to be supported by a document, if you're an LLC, called an operating agreement. And the operating agreement is going to tell the investor how the company is run. So the private placement memorandum, operating agreement, and that's all tied together with this agreement called the subscription agreement. And the subscription agreement is the investor saying, here's all my information, here's what I'm willing to invest, I've read all your documents, I understand them, I'm ready to invest. So when you're doing a 506c offering, you want to have a website that can process digital subscriptions. It just makes your life so much easier. It makes it easier for the investor. If you'd like to check out what that looks like, you can always go to CrowdStreet, that website I talked about, or you can go to Realty Mogul, you can go to Fundrise, you can go to any number of these crowdfunding websites. You can even go to Grant Cardone's website and see how he processes subscription agreements digitally as well. There's all kinds of services out there, Redwood, IMS, there's white label platforms that you can use as well. So that is one of the things that I strongly encourage you to have if you're going to go out and do a 506c type of offering. And if you already have a brand and reputation, then yes, 506c might be the right decision for you. So just to break down the rules real quick, and I'm going to tell you right now, look, if you want, text the word crowd to 36260, and I'm going to send you a chart that's better than this chart that will tell you all the rules, tell you exactly what's involved. So if your hand's hurting from taking notes and you just want to have the chart, just text crowd to 36260 and that will send you the chart back. Okay. With that being said, I am ready to take questions, and I hope you guys have some questions. Going over here to the little chat, go to the Q&A box. Please post. We don't have any questions. Ah, I'm so sad.
I can't believe that. I can't believe that nobody has questions on SEC regulations.
I highly doubt nobody has questions. Usually I talk really fast during these things because I run out of time on questions. So I'm a little shocked that people don't have questions. And Denise just asked a question that just says question. Denise, that's not a question.
And Jillian, the 36260, is that the number? 36260?
Yeah, 36260. Text the word crowd, and I'll get you out that.
All right, I just posted
nice
that.
So it's a really cool chart, actually. I'm quite proud of it, to be perfectly frank.
Yeah.
So, okay. So Denise asks, are the PPMs fairly standard in format? I mean, the formatting of the PPM, yes, is absolutely standard. There's things that have to be in there, but they're unique in the sense that each deal is unique. And so you do need to have uniqueness when it comes to risk factors. You have to have uniqueness when it comes to the story. The distributions might be unique in nature. The preferred return, if there is one, might be unique in nature. The terms and conditions of the deal might be unique in nature. So yeah, it's standard. I mean, obviously you will know a Trowbridge Sidoti PPM if you saw one, because we use the same font. I mean, we've actually had discussions about this. We want people to be able to read our documents, know it's a document that came from us, and know exactly how it's going to read. So yes, our documents are very standard. They come in a very, one of the things we do in our particular documents is we make sure our PPM completely tracks with the operating agreement. That's something we're extremely proud of over here. And that's really so that the investor and the sponsor have an easy time understanding it, reading it, digesting it, knowing what's in there. So yeah, so I would like to say that, yeah, there is a standardization to them. I will tell you right now, I've read plenty of documents that are hot mess documents, which is why for me it's so important to have some kind of standardization with the PPM to make sure it reads well and reads easy for the investor, so the investor knows easily how to find something. So what type of attorney would you suggest to draft the required complying documents? You want a securities transaction attorney, a securities attorney. And you're of course welcome to call me if you'd like assistance with that. But don't go to just a real estate attorney. A real estate attorney is really not going to understand securities transactions the same, just like I would not do your real estate closing. So you really want a securities transaction attorney, and preferably one that understands real estate if you're going to be doing real estate deals. Okay, so those are all questions. Thank you for our one question.
Yeah, no. So, on going back to the standard formatting of the PPM, so are banks or lenders going to require certain verbiage in the PPM?
Right. Yeah, they do. So we're used to that, we're definitely used to that over here. So we usually, what we end up doing is we send the way the client wants it. We send the operating agreement. They don't really care about the PPM. The banks usually don't care about the PPM. They care about the operating agreement. Yep. And so we'll send the operating agreement on over to the client the way they want it, knowing that the bank might come back and say, we need you to amend to read this section to read this way. So we're very prepared and used to that. It happens all the time. Things like about special purpose entities, making sure that there isn't going to be any other debt, stuff like that. So yeah, banks do care about what that operating agreement says for sure. They also care if there's any 20% or more owners. So actually, one of the things we automatically put in our operating agreements and in our PPMs is warning investors that if you are a 20% or greater owner in this deal or in this company, then you might be subject to the bank when we go to get a loan. So we suggest no one invest more than 20% or be a 20% or greater owner.
Right, yeah. Otherwise, you'll be underwritten.
Yeah, exactly.
As a loan guarantee. Yeah.
Mm-hmm.
Yeah. Mm-hmm. Yep, definitely. Yeah, we actually had to do some modifications to operating agreement this morning for that very purpose. So
yeah,
it happens. It's part of the hoops.
It is. And I want to encourage you guys, ask questions. If you want to ask questions, you don't have to stick to this presentation here and what was happening here. If you want questions on, what's the best way to go out and raise capital, which I'm going to just answer right now. But, any kind of question you have regarding raising private capital for real estate deals, go for it. Ask. I'm happy to answer. You don't have to stick to this particular subject. This was the subject of the day, so that's what I talked about. But if you have any kind of questions regarding raising private capital, let me know. One thing I do want to talk about is what is the best way to raise private capital. And I alluded to this earlier on in the presentation, which is that it is really education-based marketing. So if you're in multifamily, and I assume all of you are because you're here, watching this right now, if you are in multifamily, then what you really want to do is become an expert on your area of multifamily, whatever that might be. So maybe you like to buy only small apartment buildings, 20 or less units. Become an expert on those 20 or less units and then talk about why 20 or less units are so great. This is going to translate. People are going to come for the education, stay for the investing, right? Once you prove yourself as an expert in your very specific space, people will learn to trust you. I see it happen all the time. It's how I invest. I don't invest based on advertisements ever. I never see something that says earn 15% on your money and I go, oh my God, I got to invest in that now. It's always about the person who has, some kind of level of knowledge that is unique or different or proves that they've really looked into something. So, I have this other program called Private Money Rockstar where I teach people the marketing and the legal aspects of raising private capital. And one of my students in Private Money Rockstar, I asked him, what are you going to teach people? How are you going to convince people to invest with you? What is it? What makes you unique? And he said something to me that made me go, oh my God, I want to hear more about that. And what he said to me was, learn how to save for your kids' college education by investing in notes. That blew my mind. And I'll tell you why it blew my mind. I don't save for my kids' college education. Why? Because I don't necessarily trust Coverdale's or any of these other traditional forms of college saving because they're so restrictive. What if your kid doesn't go to college? And I probably shouldn't say that, but what if your kid doesn't go to college? That kind of thing. So that's a really unique proposition. You know how I can save for my kids' college education? By investing in notes, which is probably a much better investment opportunity than a Coverdale. I want to hear more about it. And he'll go through that whole thing. And, it turns out I don't want to hear all about it. I want him to just do it for me. So that's what you're looking to do. You're looking to overwhelm with information so that people realize you're the one who knows what you're doing. Why don't they just invest with you? It happens all the time. So that's really what I want to encourage you to do. Okay, so we have a question here. Tony asks, we raise funds in Canada. Do we need a PPM? Thank you. Well, it depends. Are you raising money for projects here in the United States? And if you are raising money for projects here in the United States with Canadian investors, then absolutely yes, you need a PPM. Canada and United States have really, a reciprocal relationship when it comes to securities laws. They're governed by a lot of the same rules. And one thing I will say about Canadian investors, though, if you have an American company that's raising money in Canada, you don't want to use an LLC. You want to use a limited partnership. Why? Because the United States and Canada has a special tax treaty for Canadian investors that doesn't subject them to the 35% withholding that is normally done with foreign investors. And that's a special rule with Canada only. And it doesn't apply to LLCs. It only applies to limited partnerships, because when the tax treaty was written, limited liability companies weren't that popular. So you have to use a limited partnership with Canadian investors. And yes, if you're raising money, especially for use here in the United States, I strongly recommend just following United States Regulation D rules as they are with Canadian investors as well. So
you were talking about the best way to raise money, and you talked about different regulation. You have the Regulation A, and then the Reg D, 506B, and 506C. So we've had experience with 506C and B. So our question is always, what is the best way? Because one, you can advertise, or you can solicit, and one you can't. One requires one's self-accreditation, one's not.
Right.
So we're always trying to weigh the balance of those and what is most beneficial. But I think you hit something on the head when you said you've never invested in something simply because it was advertised.
Right. Right. So I don't mean to keep using Grant Cardone as an example, but he is like the most public example I can use that you guys can all refer back to. Grant Cardone doing a 506C offering makes complete and total sense. Why? He has 6 million followers on Facebook alone. So he can go to his 6 million, and that's how we started off. He did 506C offerings, realized he had a ton of those people in that 6 million followers that were not accredited, that wanted to invest with him. So he parlayed that into a Regulation A offering. So looking at 506C, he has all these followers, and so he can blast out to them, hey, who wants to invest with me, and get a bunch of feedback and people back. It makes sense. He already built the trust. He already wrote 10X. He already, provided all this educational information. And if you even look at his advertising now, there's very little of it that is invest with me today. It's always followed by with why you want to invest in this type of multifamily and why he does this. It's never just a pure, hey, we're Cardone Capital. Invest with us today because we're super awesome and we'll make you lots of money. That is never the messaging. The messaging is always why this is good for the investor, not why it's good for Grant Cardone. That kind of messaging doesn't work. Desperation doesn't work. And just strict real investment advertising reeks of desperation. You've got to speak to the investor and the investor's needs. And I am going to tell you right now, the investor's needs are never a return on investment. It's something else. And you just got to find out what that else is and then speak to that and educate on that and convince the investor that you're the best one to take care of that issue for them.
So the establishment of the authority platform first. So a Reg A only does you benefit if you already have the trust or the regulation platform already in place, not just so you're able to just put an ad on TV because nobody knows who you are.
Right, or you're solving a problem, right? You're solving some kind of problem because let's take it out of real estate, because a lot of my Reg A's are not real estate. And it's because they're solving a problem. So I have this one company, for example, that is, it's called, the product's called a nested gel. And it's the company's, if you want to look it up, it's called Insight. And by the way, this is not an endorsement to invest. I'm just telling you what they do. It's called In Situ Biologics. And what so In Situ Biologics has one product called a nested gel. What a nested gel does is it's a viscous gel. It comes in a variety of viscosities. And what you can do with this gel is you can insert an opiate into the gel and then inject the opiate, and it will time release the opioid. So why is this important? Because we have an opioid addiction problem in this country. This gel will slow that down, will somewhat help prevent it without getting rid of opioids altogether. Opioids do great things for people in terms of pain management. So you can't completely get rid of them. It's a multi-billion-dollar industry. So we're not going to get rid of it. It's time and control. It's addictive. And what we can do is by this gel, making it time released, making it so the person doesn't have to inject so often or take so many opioids, doesn't have the accessibility. They go to the doctor, they get one injection. That's it. That's all they're getting. And it time releases, and it can be up to 4 months. So they're solving a problem that exists. That's the attractiveness of that particular product, right? It's always about solving the problem. I didn't say anything there about return on investment. It's implied. If this gets through the FDA process and they get to market, the return on investment is implied. So that's really what you're looking at. You need to look to solve a problem. I have another client who is looking at gentrification and how that has negatively affected the African American community. He is speaking to a totally different problem that doesn't necessarily translate into return on investment. He's saying, look, gentrification is hurting the African American community. I'm looking to solve that by buying these properties in these potentially gentrification zones and rehabbing them to the point where people who live there can still afford to live there, but we make a return on investment. But the return on investment is obviously not going to be as great as gentrification itself. He's still solving a problem for the African American community. And see where I'm telling you, it's not always about returns.
Yeah,
so.
Definitely. No, that was very insightful, and it's helpful because like there is so many options, and often when you're going to raise money, you're trying to look for the best option for what you're trying to do.
That's right.
So knowing that is very helpful, and I always enjoy, brushing up. I am not an SEC attorney. That's why we hire SEC attorneys. And so we appreciate all the detail and everything, but it's very important to understand the rules in order to play the game. So if you're not following the rules, you'll be ejected from the game, right? I guess that's the best way to put it in sports.
That's exactly right. Yeah, and you've got to follow the rules. Guys, I could sit here, we could do an entire day of me just reading cease and desist letters of people who simply didn't follow the rules. So, and didn't necessarily steal anybody's money or do anything wrong, but like I said, we could spend an entire day just reading cease and desist letters from states, enforcement actions from the SEC, whatever it might be.
Yep. Yeah, definitely. And, it's like I said, this business is, we want to do everything by the rules. And so thank you, Jillian, for showing us a lot of those rules. And thank you for jumping in. I'm sorry you had trouble getting into the room, but
no, that's my fault. And thank you everybody for hanging out. That was so kind of you.
Yeah, no problem. And again, thanks again. And hope you enjoy the rest of your day.
Thanks. Bye, guys.
All right, everyone. Thank you for listening to that presentation on SEC regulations with Jillian Sidoti. We will be coming back at 3:30.